Hey guys, so for those that don't know me, my name is Yonas. I am a physical therapist in San Diego, and we're gonna begin the presentation in about 5 minutes with Lori, the employment attorney specialist here, because there's so many questions in the Rate My Therapy company Facebook group, and a lot of the times we ask therapists a lot of legal questions when it's best to ask a professional. So it's just good that we do have a professional here. And for those that just rolled in, feel free to post your discipline and what city you're in, um, just to stay connected. And with Rate My Therapy Company, it began about 3 years ago, just out of my own personal frustration of not knowing what a job is like. I worked my first ever nursing home years ago. It was very unethical, and I didn't know what was normal and what's not normal, because a lot of the times we just do what your boss tells you to do or what the culture is. So we kind of made this community so people can just share what facilities like, so we know better, and then also to share like good companies and to share bad companies, because we always hear about bad companies, but there are a lot of good companies out there. I've worked for a lot of good companies out there too. So it's just good to talk about that, to share what is possible. And then for today, kind of just for the agenda, if we can all just save the questions towards the end. So at about like 5:40 or um, at about 5:45 PST towards the end, there'll be an opening for questions, because there's just a lot of good information that'll be shared by Lori, and she'll talk in the next few minutes. But let's see. But yeah. And then also make sure that you stay until the end, because there is a surprise. Okay. So guys, I promise this will be worth it. Just stay until the end. It'll be about 1 hour or so, a bit less than an hour from now. So just don't leave and stay to the end. There'll be a surprise and it'll be very beneficial. Okay. Ooh, and then okay, we have Deb from Tacoma, Christine or she's in Pennsylvania, Aurelia from Detroit. All right, Katie from Georgia. A
A
lot of
lot of
people
East
in
Coast.
in the East Coast, in Midwest. Yeah. Ooh, yeah. Is anybody in the Sacramento? Oh, there we go. Oh, Sacramento. I just came from Sacramento. I was there for almost a year. Is there anybody in the San Diego area? Because I would love just to meet more people. If anyone's in the SoCal area. All right.
I wish I was.
Yeah, there is some rain right now, but still, it's still a beautiful time. All right. All right. Feel free to you can have it your way, Lori. Feel free to start the presentation, I guess. We can just,
Okay.
yep, get
Thanks so
started.
much. Well, so thank you to Jonas and to Rate My Therapy Company for this opportunity to come back and talk with you. I think hopefully some of you were here about a year ago when Jonas asked me to do this for the first time a year ago. And whether you're on the West Coast and it's about 5 o'clock or so, or the East Coast, which is 8-ish, I think it's great that you're all connected across the country to exchange ideas and best practices and network. And whether you're a sole practitioner, an employee, or a contractor, or even an employer, and no matter where you are, California, which is the most employee friendly state, or a place like Texas, which is kind of the opposite, um, hopefully the topics today will be relevant to you and will be interesting. I see that some of you are from Michigan. I actually have two daughters who are both in healthcare. One is a counselor at an eating disorder facility, and the other one who lives in Michigan and said, I wonder if any of them work at any of my hospitals. Anyway, she works at University of Michigan Hospital getting her fellowship in neuropsychology with children. So she does work with occupational therapists and physical therapists. And it has certainly been an interesting and challenging time for employees, especially in healthcare. you know, while we're out of the major issues from COVID, thank goodness, health and safety concerns and working on site are still issues, and probably, you know, more focused on those issues now than ever. And you have very close contact with patients, and there's masking and, you know, all kinds of protocols still that a lot of the public doesn't deal with. And we also know that there are staffing shortages in healthcare, in your industry, which, you know, causes people to have pressure on everybody, really. It leads to challenging work environments. I'm sure there are people that have short tempers and they're overworked and they're not sleeping well, and there's arguments and burnout, and you're working excessive hours. And it's hard on the company side to attract and retain employees. And obviously, that's in other industries as well. We have the great resignation, people leaving their jobs, going into other businesses like financial, helping people with finances. And we have a lot of people starting their own business or moving from one employer to another. So non-competes have been an issue. And then there's been a lot of doubling down on hiring. Well, there was in the pandemic, and suddenly the companies that were hiring many people, especially in industries like tech, now they're laying them all off, or many of them, because they hired too many. So I'm Lori Goldstein. I have my own solo employment law practice in Chicago, near Chicago, Illinois. I've been practicing for about 40 years. The first 27 years I worked on the employer side at two different large Chicago law firms. And then since 2011, I've been on my own, representing both employers and employees, not at the same company. I work with a lot of healthcare providers, from individuals like physical therapists, nurses, doctors, PAs, a lot of mental health care practitioners, and practices that are just growing and booming. And, you know, it's a big industry. And I hope, you know, companies, really anyone from, you know, that has one employee to 500 employees across the country. So let's get to another slide, because you've been watching this one for too long. So our agenda today, there's new developments in employment law all the time. Yonas kind of clued me in on a few hot topics that have been prevalent among your the physical therapists and your group. And generally, a lot of what I'm going to talk about can apply whether you own a company, whether you're work for a company that's just has one or few employees, or a big company. And we'll see that certain laws will apply based on how many people work at the company. A lot of times, if it's a small company, there's a lot of federal laws that don't apply. We will talk about classification of workers, which continues to be a hot topic. Really, whether somebody is a 1099 contractor or a W-2 employee. And a lot of times it's confusing to companies, it's confusing to the workers. A lot of attorneys don't understand it, and that's why there's a lot of lawsuits. There's audits. People file claims for being misclassified, and it costs a lot of money to companies. So we will talk about you know, how that's changing, and there's a new final rule from the Federal Department of Labor that is going into effect on March 11th, so 5 days from today, and we will talk about that. We'll also talk about what at-will employment means and what rights you have, which means not many. We'll talk about something that's also prevalent in your industry, work hours. You know, what's allowed and what's required for breaks, and what does overtime mean, and who's supposed to get paid overtime, and what does that mean? That's also an area where there's misclassification often. We will cover discrimination and harassment laws, which are always a hot topic and very important, and disability accommodations, which again are the kinds of things that I get questions about all the time from employees and employers. And you guys deal with this not only on your own for your own health, but probably you're dealing with patients sometimes who are on leave or having some kind of accommodations from work. So you may hear some of their stories. And then we'll talk about benefits, kind of what are the latest benefits that, whoops, that employers are using now to attract and retain employees, and what are some of the rules about those. And we'll end with non-competes. There's also new law or possible new law coming on non-competes, plus state law. Non-competes are based on state law, and states change their laws all the time on non-competes. So every time I do this presentation, there's more states that have outlawed non-competes. California is not the only one anymore. So the PowerPoint will take about 40 minutes or so, and then we'll save time at the end for questions and answers. And I hope that you get something out of this, that you can bring up at the end some situations that you've dealt with or you've heard about, or you always had questions about, and we'll go from there. So we'll start first with worker classification, whether somebody's a 1099 contractor or a W-2 employee. And this is something that some of you may be familiar with, because depending on where you work or who you've worked for, you may have been a W-2 at times, you may have been a 1099. Sometimes you have more than one job, and for one company, you might be their employee, and you may also be doing some side business as a 1099, or you may just have your own side business where you're also a 1099. But a lot of companies don't understand and tend to misclassify, because it's obviously cheaper to have a contractor. You don't have to pay benefits. You don't have to pay overtime. They're not usually covered by many employment laws, and it's just a lot easier. So a lot of companies prefer to have contractors, but you can't just decide, okay, you're going to be a contractor, nor can the worker decide, I want to be a contractor. My accountant says, let's do it this way. That doesn't work under the law. If you should be an employee, and a company therefore should be paying payroll taxes and FICA and Social Security and unemployment, all those government agencies want that money. And so they don't like when these companies just call people contractors and they aren't paying in the way they're supposed to. So there's a lot of times that there's audits, claims get filed. Sometimes a contractor might file an unemployment claim, which are usually only for employees, and they may just file it either because they think they might be entitled to it. During the pandemic, a lot of states, including Illinois, allowed contractors to get unemployment. So it could be as simple as that. And then the unemployment agency starts digging deeper and realizing that, no, you weren't a contractor, you should have been a W-2, and they look further and see that all 80 employees at that company should be W-2, and now we're going to tell the IRS, and then the company has trouble. So there's a lot of misperceptions about it. You can't just have an independent contractor agreement and everybody signs it, and that means you're an independent contractor. There's also something that's called perma-temping. I don't know if you've heard that phrase before. I had never heard that before, but in Illinois, just this year, and I know in some other states they've done this already, we have a law now that I think it starts April 1st. If there are contractors working for a temp agency, and that temp agency assigns them to work for a hospital or a clinic or a medical practice for more than 90 days, then the temp agency has to pay them the same amount of compensation and give them benefits or monetary value of the benefits that a direct hire would get. And that's the whole idea, is to try to avoid this making somebody a permanent contractor. If you want somebody to work for you, for that long, then make them an employee, give them benefits. They should be treated like employees. So we have those rules. We now have also this rule from the Department of Labor that I said is coming out in a few days. It's a final rule that's basically based on a proposed rule from I'm trying to think, from 2022. And now this is the final rule that makes it a lot harder for a company to say that somebody's a contractor. So this is an employee-friendly test that has 7 factors, and I've listed them here. One is how much control does the company have over the work, which has always been the hot, the biggest factor of, is this a contractor or an employee? Who's deciding where they work, when they work, how they do the work? So control, but that's only one factor. So another one is, does the person have opportunity to have profit or loss based on their investment or initiative? For example, if you have your own company, you have an LLC, and you work for a lot of different practices or doctor's offices or hospitals, you have an opportunity to do well, to profit or loss based on your investment in a business. Also, if you invest in equipment for your business as opposed to the company providing that equipment, your investment in the equipment is usually a sign that you're a contractor. But just because a company says you have to pay for your own equipment doesn't make you a contractor. They could be violating employment laws that require them to pay for employee expenses, and they're trying to get out of that. Another factor is how much skill is required. So the less skill required for the type of job, the more apt it is to be an employee and not a contractor, whereas a contractor has a special skill. Somebody doing finance or somebody doing accounting or something, that you would outsource, even HR, they have to have some special skills to do that. Another factor is how permanent is this working relationship? And that kind of gets back to the permatemping. I've had companies come to me all the time. Well, we have this 1099. We want you to, will you review the contract and update it? How long has this person been working for you? Oh, 6 years, and they're still a contractor. And, then I have to tell them that it isn't really even ethical for me to draft or update an independent contractor agreement. They should be an employee. And then most of the time they listen to me and we convert them to an employee and we create an employment contract. Sometimes the company doesn't like what I tell them. And then I had that happen once. A company that had 500 people working for them, they told me 250 of them were temps. They had been there for 20 years, like, families and second generation. It was, a die casting company. It was a family business. And I was trying to explain to the grandson who was inheriting the business, it doesn't work that way. And he didn't like my advice. And he went to another law firm, and he got audited, and there were violations, and they had to pay penalties. So, and then another factor is the work that the person's doing, is that an integral part of the company's business? So, if your company makes widgets, and you're hiring people to make widgets, that's your business. Those people should be employees. But if you're hiring somebody to do, accounting, bookkeeping, HR, that's not your business. That's kind of a side business. And then the new rule has something called additional factors, which is just kind of a catch-all that says, if there's any other, I'm trying to look for the actual words, but it's kind of, if there's any other factors that makes it seem like this should be an employee or should be a contractor, then we're going to take that into account. So it's a lot to digest, and companies are going to have to should be looking at, their classifications now, and anybody that they're treating as contractors, they should double check and make sure that that's really true and appropriate, or they can get in trouble. Okay, then we have at-will employment, which is always an interesting area of the law. Usually people will call me and say, we're in an at-will state. right? That means that, I could get fired for any reason. Um, there really isn't, there really aren't at-will states. At-will means that the company can let you go at any time for any reason or no reason without notice. And you have the same right. You can walk out the door and say, I'm leaving. You don't have to give notice. You don't have to give a reason. That's what at-will employment means. So it means you don't have any job protection. There's no specific duration. You don't have a contract that says you're here like some teachers do. You have a 1-year contract, and we can only fire you for cause for certain reasons. Most employees are at will. Most people don't have the protection of an employment contract. And but sometimes you do, depending on your position or your role or the industry. Sometimes you might be able to get a contract that either has a specific time frame or gives you kind of the opportunity to get severance pay if you get fired without any reason. So sometimes you can get some kind of guarantee that if you, and, unless I get convicted of a crime or, I do something terrible at the company and they define it in the contract, then if you fire me just because you don't decide, you don't like my face one day, you're going to pay me 2 months or 3 months of pay. So you get some benefit out of it. Also, if you have a contract or even oral promises of employment, sometimes that gives you more protection than being just at will. And sometimes an employee handbook, depending on the language that is in there or is not in there, can become a contract. And an employee can use that as a way to sue a company for not following their policies. Usually, if they have good employment lawyers, the company will have an employee handbook that says all over the place, this isn't a contract, you're at will. It puts it, it highlights it, and there's fireworks, you're at will on every other page. So those kinds of things courts look at to say, the employee knew that they were at will. Sometimes if there's a progressive discipline policy, which says, if you do any of these bad things, first we're going to give you an oral warning and then a written warning, and then we'll suspend you. And then if you do it again, we'll terminate you. If you have something that's that specific and in a handbook, sometimes that can become a contract, and that gives employees protection. Let's see. Or if you have something called a probationary period. So the company says for the first 30 days, 90 days, you're on probation. And after that, you're going to be a regular or a permanent employee. Some courts have said if you call it probation, then once they successfully get past that period, they have more job protection than just being at will. So, however, being fired without cause doesn't mean any reason. So you can't be fired legally for cause. Without cause, if it's for a discriminatory reason or another unlawful reason. And we'll talk about discrimination in a minute, but so without cause doesn't give a company just, any reason at all. They have to be within the law. Okay, and we will get to discrimination in a few slides. But this is also a big topic that Yonas mentioned. And this also is something that ends up with misclassification. And that's whether somebody is exempt from overtime. Exempt means you don't get overtime. It's confusing. Non-exempt is like a double negative. Non-exempt means you do get overtime. So most employees are non-exempt, which means that if you work more than, federally, and it depends on the state, but in most states, if you work more than 40 hours in 1 week, then for all of those excess hours, you get time and a half. You get 1.5 times what your standard hourly rate would be. That's overtime compensation. There's some states that if you work on weekends or if you work more than 8 hours a day, you get overtime. But that's the general idea of overtime. If you're exempt, meaning you don't get overtime, it means you have to work as much as possible to get the job done. So that could mean 24/7 if that's what it takes to get your job done. And, there's a lot of employees that are exempt. Um, and the way these are defined in the law, to be exempt, there's 3 requirements. First of all, you have to have a minimum salary of $35,568 a year, which isn't very high. It was 23,000 a few years ago, and finally the government raised it to this. They're talking about raising it again. I think the last time around they wanted to get it to 50 or 52,000, and so many businesses said no, that they compromised at 35. So it's not hard to be over that minimum. Also, you have to exercise what they call independent judgment and discretion. So you are not just following rules and following orders and doing what somebody else tells you to do. Your job requires you to have some independent judgment, to have discretion on important decisions. So, even as a physical therapist, I'm sure there are times, based on depending on how the patient is and what kind of issues they have and how they are a certain day, you have to decide what you're going to do with that patient. And I'm sure that it's more than just following a certain, rubric. And then we have what we call the primary duties test. So that this is the main one. You have to kind of fit into a certain category of jobs. Either you're an executive, which means you're in charge of the whole company, or you run a department or a division or a team, and you have to supervise the equivalent of 2 or more full-time people. Or you can be in the professional exemption, which I think most of you or all of you would be. You're licensed, you are in a field of intelligence, what do they call it? A field of knowledge. Work requiring advanced knowledge, predominantly intellectual, or advanced knowledge in a field of science or learning. And then there's the administrative exemption, which is a gray area, and many people don't understand it. And some companies think it just means anybody that is a file clerk or works in the office is an administrative, and that means they don't get overtime. And it's not that. They have to have they have to work in the back office and either be working on the, basically the business of the company or the company's clients, but they also have to have independent judgment and discretion. So it's not a receptionist or somebody answering the phones. They have to have more important jobs. So if you fit into all of those, then you would be exempt. Salary is very important. If you don't earn salary, if you're not paid salary other than certain jobs, such as sales reps who get commissions, and also doctors and lawyers. Otherwise, if you don't get salary, then you're not exempt, even if you meet all of these other things. So if you're paid up by the hour, a lot of companies get in trouble with this. Then you're not exempt. I recently settled a case for a CPA who was working for 10 years at a company, and she kept asking them why they weren't paying her a salary, and they said, we don't want to pay you a salary. So they paid her hourly, and she worked overtime all the time, and they paid her the same amount for the overtime hours as her regular hours. And we just got her $30,000 of back overtime. And this is an accounting firm she worked for. They should have known better. There's also an exemption for somebody called a highly compensated employee, where you have to earn salary, and it could include commissions and bonuses of about $107,000 and change. Plus, you have to have one of the primary duties: executive, professional, or administrative. And then we get to discrimination and harassment, which anti-discrimination laws are found under federal law, state law. A lot of cities have these laws, counties as well, and it really governs all aspects of the employment relationship. The basic rule is a company can't discriminate or harass somebody based on a legally protected category, and they can't retaliate against them for complaining about discrimination and harassment. So the federal laws that apply are Title VII of the Civil Rights Act, which covers many types of discrimination. It's race, national origin, gender, sexual orientation, gender identity, citizenship. There's many categories that are protected. These apply to companies with 15 or more employees. The Americans with Disabilities Act, the ADA, which a lot of you probably have heard of and dealt with. This covers employers with the same size, 15 or more employees, and it prevents or prohibits discrimination and harassment based on having a current disability, a past disability, or even being perceived as having a disability when you don't have one. And it also requires employers to provide reasonable accommodations for people with disabilities, such as a leave of absence or an afternoons off to have kidney dialysis, reasonable accommodations. And again, you probably deal with this in your business. And then the Age Discrimination Act covers employers that have 20 or more employees, and it covers people age 40 and older. So that's the protected age class. And again, no discrimination, no harassment or retaliation based on age. And then we have a lot of state laws and local laws that apply to employers of different sizes. So depending on where you are, and when I have a client that, for example, might be in a small town in Texas, I look up Texas law, but I also look up the city and the county where they're at. And sometimes there's county laws that apply if you have 5 or more employees in that work in that county. And if I have a client that only has 2, it doesn't apply. Most state laws and a lot of local laws apply to employers with 1 or more employee. So usually most companies are covered. And Illinois and a few other states now protect independent contractors from discrimination and harassment. So discrimination means basically being treated differently because of a legally protected category, such as some of the ones I mentioned: race, age, disability. It doesn't mean being treated differently for reasons that aren't covered by the law. So sometimes you may see that somebody else is getting favors from the supervisor because they are friends or they used to work together, or they like each other more than the supervisor likes you. And all of that is totally unfair and totally unprofessional, but it's not based on any protected category. So it's not illegal. And many times people call me and I have to listen. I listen to their story and have to explain that it's unfair, unhealthy, unprofessional, but it's not based on your race or your age or your gender. It's just something that's, shouldn't be happening at work. You should find another job, because a lawyer can't really help with that. Harassment, in order to be illegal, and we hear about this hostile environment all the time. Hostile environment doesn't mean it's an angry environment or it's toxic or people are yelling at each other or the boss is a bully. Hostile environment under the law means it has to be unwelcome, verbal conduct or physical conduct, and again, has to be based on one of these legally protected categories. So it has to be based on age or national origin or sexual orientation. It's not just general bullying or general abuse. And again, I sadly have to tell people all the time, that's a terrible thing to have to go through at work, but it isn't illegal. And if you have a bullying boss, take a leave of absence, go find another job, because it's not going to change. The company doesn't have to do anything about it. And it's sad, but there's no anti-bullying laws yet. And you also have to show that whatever that harassment is, is unreasonably interfering with your work. So it's gotten to a point where it's offensive or it's really keeping you from being able to do a good job. And then retaliation means an adverse action, work action. You get demoted, or you're denied a bonus, or you get put on a performance plan, or you're fired because you made a good faith complaint that you felt that you were discriminated against or you were harassed based on a protected reason, or you complained about somebody else, or you participated in an investigation for somebody else's complaint. You should not be retaliated for that. That's illegal. So again, if you complain that my boss is a bully and you get fired over that, it's unfair, it's unprofessional, it's not illegal. And that's again another myth that people, don't understand. Well, but that's retaliation, but it isn't illegal retaliation. Okay, then we get to disability accommodations, which is kind of a part of the whole discrimination and harassment laws, that companies have to provide reasonable accommodations that would enable somebody to perform the essential functions of their job unless it causes undue hardship to the company, which is a lot of legalese. And this is why we have lawyers and judges and juries, because it's not black and white. And when an individual has a disability, really it's up to medical professionals. It's not up to the company and it's not up to the employee to figure out what they might need to be able to do the job. So when I have a company that comes to me and said, our employee tells us they have a disability and they need to take Fridays off, I say, give them this medical form, have their doctor fill it out, then bring it back and let's see what the doctor says. Because sometimes the doctor says they need, 6 months off, or they need a new supervisor. Those are not reasonable accommodations. Reasonable accommodations would be a leave of absence, generally of up to 12 weeks, maybe a little bit more, or, part-time work, but it's not permanent. This is temporary accommodations. And if it's an accommodation at the workplace, it has to enable them to perform the essential functions. So if there aren't any accommodations that would allow that, for example, if the employee says, or the doctor says, you have to give all of the heavy lifting and all of these major parts of their job to somebody else for the next 3 months, they can do typing. That's not a reasonable accommodation, because you still have to perform your essential functions. So when you see a job description, that's what those are for. They tell everybody, these are the essential functions. And if you can't do them, you don't have to be given accommodations. So accommodations can include giving you special equipment, a part-time schedule, maybe working from home, things like that. The disability laws also require employers to maintain confidentiality of your medical information and your requests and your doctor's notes. So all of that information is supposed to be in a file that's separate from your personnel file, and they're not supposed to discuss it with everybody at the company. If you have a disability situation and need accommodations, you should go to HR or whoever at the company's in charge of human resources. You don't need to go to your boss, and your boss doesn't need to know all these details. They only need to know what they need to know. So you go to HR, let them look at the documentation, and then they can tell your boss she's having Fridays off. They don't have to tell the boss why, other than this is a disability accommodation. They don't need to know what your disability is or what your prognosis is. So you don't need to tell that to your supervisor. And also, companies need to know that if they have attendance policies, they can't discipline people for absences or tardiness based on a disability. So you can't have a policy that says 3 strikes and you're out. We don't care why you weren't there that day, or we don't care why you were late. If it's for a disability reason, they can't count that against you. Okay, and I want to make sure we have time for questions. So these are just some benefits that companies use, and have been more prevalent than ever because, again, it's hard to attract and retain employees. So we have a lot of states now and some cities, including Illinois and one of the county where most of us are in, Cook County. We have laws now that require employers to provide for full-time employees 40 hours of paid leave every year, which is a great thing. You know, not all employers provide vacation or PTO. Some of them, they don't have to. Now they have to. So this requires employers to provide paid leave for any reason. And if you aren't full-time, basically you earn 1 hour for every 40 hours you work. So even if you're part-time, you still earn paid leave. We also have paid sick leave laws that now require companies to provide sick leave and pay for it. Otherwise, people would feel like they can't afford to take sick leave, which is wrong. We have family leaves. A lot of states, some states have disability leave. If you're at a company that has 50 or more employees, you would be covered by the Family and Medical Leave Act, FMLA, which provides unpaid leave of up to 12 weeks in a year for your own disability, to take care of your family, for birth, adoption, and foster care, and bonding with the baby. So that's a great statute, and there are more and more states that are providing that as well. Some companies offer short-term disability benefits so that you get paid generally 2/3 of your salary while you're on leave. A lot of companies now have parental leave that, you know, even if the states don't require it, they provide parents, regardless of mother, father, whoever they are, they provide them with leave to bond with a baby. So there's a lot of creative things that companies can do. And then finally, the last hot topic is non-competes and non-solicits. And we know this has been a focus of the federal government, a lot of states for a long time. California does not allow non-competes. There are several states that don't allow them. There are a lot of states that won't allow them if your salary or your earnings are below a certain amount, because low-wage workers should not be subject to these. So a non-compete means that you can't, you know, for a certain period after you leave, or even during employment, you can't work for a competitive business. You can't have your own competitive business. Generally in the healthcare practice, you can't just have a broad non-compete. Sorry, you can't be an occupational therapist for a year. You have to have a radius for doctors for healthcare, because patients have the right to decide who their healthcare providers are. And a company can't have something that's even 5 miles is a lot. If you make it 10 miles, then it's going to be impossible or very difficult for the patients to get to those doctors or therapists or nurses or whoever they want to see. So they have to be a reasonable scope of geography as well as duration. 1 to 2 years is really the most. And that's what a non-compete means. You can't work for a competitor or be one. A non-solicit is not, doesn't say where you can or can't work, but it says that no matter where you go, you can't solicit away our patients or our clients. You can't contact them and say, I'm here now, come with me, leave this place and come over there. Those are a little, they're less restrictive. They're easier to enforce. But even with, I have found, with therapists, with healthcare, with mental health therapists, if patients want to follow their provider, they're going to follow them. So you can keep, you know, yes, you can, I mean, ethically, I don't even think it's ethical in healthcare for the practice not to tell the patients that you're leaving and where you're going. And I think it's probably on your side not ethical for you, at least not to tell them that once you've left, for them to be able to contact you. So it's different in other industries where, you know, if you're a salesperson, you should not be contacting those clients to try to get them to buy widgets at a competitor. So we have lots of state laws, including Illinois, that says that having at-will employment is not enough to enforce a non-compete or a non-solicit, which means that if you start a new job or you're in a job and the company says, here's this non-compete agreement, sign it or you can't work here or we're going to fire you. But otherwise you're at will and you sign it, we could fire you the next day because you're at will. That's not allowed. So in states where we have more than at will employment as what we call consideration, something of value, you have to get a signing bonus or the right to get severance if you're fired without cause or stock options, something at the time you sign the agreement. Otherwise, unless you stay employed after signing that for 2 years, the company won't be able to enforce it. So that's restricting a new restriction in a lot of states. And in Illinois, we also have minimum salary. So your W-2 earnings have to be at least 75,000 to have a non-compete, and they have to be at least 45,000 to have a non-solicit. You have to have time to review the agreement before you sign it. And if a company sues an employee or a former employee for a non-compete or non-solicit and they lose, they pay your attorney's fees and costs. So that hopefully I didn't go too fast and it wasn't that too confusing, but I wanted to leave room for questions. So please feel
Yeah,
free to
I got something
ask
there.
away.
So thanks so much, Lori. That was a lot of packed information in a short time. So guys, feel free just to say thank you in the comments and feel free to share one thing that you learned in the chat. Thanks for staying towards the end before the questions, because now we'll just ask questions. But Lori mentioned to me earlier that she does a free 15-minute consultation, and over here is her information. So for those that were here, feel free to take a screenshot of this or a picture to do a free 15-minute consultation. And if you guys do have questions, feel free to raise your hand and then we'll just go by that. Yeah, feel free just to show your face and ask the question if you feel comfortable. And then I'm going to stop recording it because some questions could be personal, so we don't want to record that. Whoops, let me, or maybe this wasn't, wait, it wasn't recording.
I see one question in the